Imagine this. You've bought your dream property, paid for it, every penny. You're waiting patiently for, some conditions to clear. And then someone else just swoops in, claims rights, and actively blocks your ownership. What a nightmare lawyer.
Oh, absolutely. It sounds like something straight out of a legal drama.
Totally. To have your dream just snatched away like that right at the finish line, and it looks like a deliberate, calculated betrayal.
It does. And, these complex, messy situations are exactly what courts have to deal with. They need to untangle these webs. It's not just about the land. It's promises, trust.
Yeah.
Everything gets broken.
Exactly. And that kind of really intricate situation is precisely what we're diving into today.
Okay.
We're looking at a fascinating legal case from the Seychelles Supreme Court, Weyman v. Valentino. And like you said, it's not just some dry property dispute. It's a real masterclass in how promises, conditions, and seemingly small legal points can just collide and create chaos when, multiple people claim the same land.
Yeah, our mission today is really to unpack all the twists and turns here. We want to shine a light on the specific legal ideas involved and show how the court, Judge D. Karunakuran specifically, managed to cut through this really tangled mess of transactions.
Right.
The goal is to give you, our listener, some solid insights into property law, contracts, especially, when things get really complicated.
Okay, let's get into it. Let's unpack this tangled tale of title PR 3299. That's the piece of land.
Mm-hmm.
Our story kicks off in Praslin, Seychelles, with a couple, George Marcel Amable and Marie Claire Amable. They owned the property originally, but, right from the start, there were these significant legal tripwires. 2 of them, actually.
That's key. They bought the land from the government back on June 21, 2001. But it wasn't a simple purchase. It came with a really specific string attached to conditions subsequent, technically.
Okay, what did that mean exactly?
Basically, they couldn't sell it to anyone else for 5 years, not without offering it back to the government first. So this was a major restriction, and it was officially entered against the property in the land register, a clear warning sign for any potential buyer, really.
A critical detail. Okay, so despite this clear 5-year restriction, on February 4, 2003, so well before the 5 years were...
Yeah, way before.
The couple signs a promise of sale to this guy, Gianluca Valentino, for 220,000 rupees. Now, you're probably already thinking, hang on.
Definitely raising flags.
Right. Because beyond that government restriction, Valentino himself, he was another hurdle.
Precisely. 2 immediate problems. First, like you said, the 5-year restriction was still very much active. Couldn't just ignore that.
No.
And second, Valentino, at that specific moment, wasn't a Seychellois citizen. Now, he was waiting for his citizenship, but at the time of the promise, no. And under the law, the Immovable Property Transfer Restriction Act, that was a big deal. You couldn't just buy property as a non-citizen without government approval.
But here's what's really baffling. The couple took the money, the full price.
Yes. They received the full 220,000 rupees. And they even went to a notary, Mr. Gerald Morel, and signed a deed for this purported sale. It later became known as the deed in dispute.
And the notary knew. Everyone knew about the problems.
According to the testimony, yes. Mr. Morel confirmed that everyone involved, the Amables, Valentino Fours, they were all aware of both the 5-year restriction and Valentino's citizenship status.
So why on earth did they go ahead? It seems like they were just asking for trouble down the line.
That is the million-rupee question, isn't it? The court record doesn't spell out their exact motive, but you see this sometimes. Maybe they just wanted the cash up front.
Maybe.
Perhaps they thought, Valentino will get his citizenship soon, the 5 years will pass, it'll all work out. Or maybe they figured the risk was mostly on Valentino's side.
Plausible.
Whatever the reason, by taking the money and signing that deed, they created a very strong, even if conditional promise.
So Valentino's stuck, money paid, deed signed, but he can't actually register the property yet because of these conditions.
Exactly. He's in a sort of legal limbo.
Okay, fast forward a bit, March 9th, 2004. Big news for Valentino.
Yes. He gets his Seychellois citizenship. Finally.
So that hurdle's gone. He's now legally allowed to buy property without needing special government permission.
He's cleared one major obstacle. Now all he needs to do is wait. Wait for that original 5-year government restriction on the property to expire.
Which was due when?
That was set to lift in June 2006. So a little over 2 years away at that point. It must have felt like, the path was finally clear, just needed time to run out.
You'd think so. Imagine being Valentino then. Citizenship, sorted, money paid, deed in hand, just counting down the months for that restriction to fall away. Almost there, right? Your dream property is finally within grasp.
He must have felt pretty secure.
But this is where the story takes a really, really nasty turn, a blatant attempt to just pull the rug out from under him.
It really is quite shocking, because on November 16, 2004, remember, this is still before that 5-year restriction ended in 2006.
Right, still locked.
The amiable couple does something dramatic. Without telling Valentino, they apparently authorized, colluded with, or encouraged, that's the court's language, this third party, Elise Weyman.
Ah, Weyman, the plaintiff in the case.
That's her. Now, Weyman was a non-resident Seychellois, and crucially, at that moment, she had no legitimate interest in Title PR 3D299. None at all. But she applies for restriction against the property.
Wow. And the timing suggests the intent was pretty clear.
Crystal clear, according to the court's findings later. The obvious goal was to stop Valentino from ever registering his deed when the time came. Just block him completely.
An aggressive move, but it didn't even stop there, did it? It was like a rapid-fire series of actions.
Exactly, like a coordinated attack. Within just a few days, things escalated quickly. First, November 18, 2004, the couple grants Weyman a usufructuary interest in the property.
Okay, break that down. Usufructuary interest.
Yeah, it's a specific legal right. It means Weyman gets the right to use and enjoy the property, like live there, collect rent, maybe for her entire lifetime, for free, even though she doesn't own the title itself.
Okay, so she gets the benefit of the property.
Right. Then, the very next day, November 19th, they take another big step. The Amiables revoke their own status as fiduciaries. Think of a fiduciary as like a trustee or manager of the property. They cancel their own role and then appoint Weyman as the new fiduciary.
So they put her in charge, effectively.
Pretty much. Giving her significant control, sidelining Valentino even further. It's quite the maneuver.
And then they rush to make it all official.
Yep. November 25, 2004. All 3 documents. Weyman's restriction request, the usufruct grant, the fiduciary appointment, though, they're all registered officially in the land register.
And Weyman claims she knew nothing about Valentino's earlier deal.
That's what she claimed under oath, yes.
Yeah.
Said she had no idea about the prior sale, which, raises questions about what checks, if any, were done.
So let's just pause. Put yourself in Valentino's shoes. You followed the rules, paid up, got your citizenship. You're just waiting. And suddenly, boom, your ownership path is totally blocked by this barrage of new conflicting registrations.
It's devastating.
It feels like more than just a legal fight. It's like a betrayal, like watching your property get stolen right in front of you through paperwork.
Absolutely. A real legal mess, and seemingly a deliberate attempt to just erase his prior agreement. He wasn't just inconvenienced. He was completely locked out of a property he'd paid for, facing what looked like a total breach of trust.
Which naturally leads us straight to the Seychelles Supreme Court. This wasn't a simple disagreement. It was about untangling this complex, seemingly intentional web. So Weyman, as the plaintiff, what was she asking the court to do?
Her main goal was to get the court to declare that the original transfer to Valentino was null, void, worthless. And crucially, she wanted an order telling the land registrar not to register Valentino as the owner. Ever.
So basically, validate my claims, erase his.
Pretty much. On the flip side, Valentino wasn't just defending. He filed a counterclaim.
Right. What was his argument?
He argued his original promise of sale was perfectly valid and binding. Those initial restrictions. The 5-year one, his citizenship. He argued they were either no longer relevant or had been dealt with. His prayer to the court was essentially, forget Weyman's stuff, declare me the absolute owner of PR 3299, and order the registrar to register my deed.
So a head-on collision of claims, the court really had its work cut out for it.
Definitely. Judge Karinakrit had to sift through all the evidence, the arguments, the documents. And the approach taken was really smart.
How so?
The judge identified the 4 key transactions at the heart of it all. And instead of looking at them all jumbled up, decided to examine them one by one, chronologically.
Makes sense. Like following the timeline.
Exactly. Because the judge recognized that the validity of each step depended entirely on the validity of the step before it. You had to know if the foundation was solid before looking at the walls built on top.
So what were those 4 transactions again, in order?
Okay, first, the promise of sale from the Amiables to Valentino back on February 4, 2003. Second, Weyman's restriction, November 16, 2004. Third, the usufruct grant to Weyman, November 18, 2004. And fourth, Weyman's appointment as fiduciary, November 19th, 2004.
Got it.
The court knew that if that first one, Valentino's promise, held up, then everything Weyman did afterwards might just collapse.
Okay, so the absolute core issue became the validity of Valentino's original deal. The first big question the court tackled was that promise of sale void because it had those conditions attached? The 5-year restriction, his non-citizen status at the time?
Right. Could those conditions subsequent kill the whole agreement from the start?
Okay.
The court looked at the Civil Code for guidance here. Article 1584 says a sale can be made subject to conditions, precedent, or subsequent.
Okay.
And Article 1589 is also crucial. It says a promise of sale is basically equivalent to a sale if the two parties have agreed on the property and the price.
So what was the court's verdict on this first question?
They found the promise of sale to Valentino was valid. Those conditions didn't nullify it. Why? Because the core elements were there. Agreement on the property, agreement on the price, and crucially, Valentino had paid in full. The conditions just meant the final registration was delayed, not that the promise itself was invalid.
Okay, so hurdle number 1 cleared for Valentino in court. The conditional nature didn't void the promise.
Exactly. The intent to form the agreement was clear, even if execution had to wait.
Right. But that brings us to the second major question, the really tricky one. Was the promise void because Valentino was a non-Seychellois when he made the promise? That violation of the Immovable Property Transfer Restriction Act.
Yes, Section 3.1.
Yeah.
This is where the court's reasoning gets really, really interesting and, frankly, quite clever.
How did they handle that? Because the act seems pretty clear. No buying property if you're not a citizen without permission.
It does seem clear. But the court didn't just say, yep, illegal, case closed. They looked at a precedent case of Due v. Winstanley. And this precedent helped them see the promise of sale not as one single thing, but as having two distinct parts.
2 parts, okay.
Yeah, part 1, the seller's promise to sell. Part 2, the buyer's promise to purchase.
Ah, I see where this might be going.
Exactly. The court performed what you might call legal surgery. They said, okay, Valentino's promise to purchase was unlawful at that moment because he was a non-Seychellois. That part violated the act.
Right.
But the Amable's promise to sell, they were Seychellois. There was nothing illegal about them promising to sell their property.
So they separated the 2 promises within the one agreement.
Precisely. They found the agreement severable. Think of it like if one clause in a contract is illegal, does the whole contract fail? Not always. Sometimes you can just cut out the bad part. Here, they cut out Valentino's unlawful promise to buy, but kept the Amable's lawful promise to sell.
Wow, so what did that leave Valentino with, legally speaking?
It transformed the agreement into what's called a unilateral promise of sale, like a one-sided promise, essentially. The Amables were bound by their promise to sell to Valentino.
Okay, a unilateral promise. Does that mean Valentino owned the land then?
Not quite. That's a key distinction. A unilateral promise creates a personal obligation on the sellers, the Amables. They have to sell to him once the conditions are met. Lawyers call it an obligation to fair, an obligation to do something.
And not ownership yet?
No, it doesn't create a real right, a direct right in the property itself for Valentino immediately. He didn't own it yet, but he had this very strong binding promise from the owners. And that promise stuck unless they formally renounced it or gave proper notice, which they hadn't.
And this impacts third parties, like Weyman.
Absolutely. Critically, the law states that a third party like Weyman could actually be held liable for damages if they interfered with that promise, especially if they, say, colluded with the sellers to break the promise, or even if they just knew about the promise when they got involved.
So, summing up the court's view, even with the citizenship issue and the conditions, the core agreement with Valentino held up as a valid, binding, unilateral promise of sale.
Correct. That initial promise was declared legitimate. It established Valentino's primary claim, a solid foundation that couldn't just be ignored or swept aside by later deals.
And the fallout from that finding was huge for Weyman's claims, wasn't it?
Monumental.
Okay.
Because Valentino's initial promise was valid and still active, all 3 of those subsequent actions involving Weyman just collapsed.
So the restriction she filed,
Null and void.
the usufruct interest she was granted,
Null and void.
her appointment as fiduciary,
Also null and void. The court declared them all null and void ab initio,
meaning
void from the very beginning, as if they never legally existed. It completely wiped out Weyman's claims and confirmed that Valentino's original agreement took precedence. That chronological approach was vital. The first valid promise beat everything that came after.
So the final judgment, which came down on November 16th, 2011, what did it officially say?
It was a clear win for Valentino. Landluca Valentino was formally declared the absolute owner and proprietor of title PR 3299 Justice, finally.
And the original deed he signed with the Amables.
Declared lawful and valid. The court then ordered the land registrar to register that deed, making Valentino the official owner on paper. They also ordered the registrar to remove any other restrictions, obviously meaning Weyman's ones, and calculate the stamp duty owed.
Any word on costs?
Yes, costs were awarded to Valentino as well. A complete victory, really, and a strong signal about the importance of honoring prior agreements, even conditional ones.
What a fascinating case. This whole deep dive into Weyman v. Valentino, it really shows how these incredibly tangled property fights, with all the overlapping deals and tricky timing, can be carefully picked apart by the courts.
Absolutely. We've really seen the power of legal principles like, how conditional promises work, and especially that idea of severability, being able to separate parts of a contract.
Yeah, that was key.
And the big takeaway for you, the listener, I think, is understanding that crucial difference between a promise to purchase versus a promise to sell, especially when laws restrict who can buy property.
Right.
It just highlights how one seemingly small detail, a condition, someone's legal status at a point in time, can completely change the outcome of who owns what, and how courts look at the sequence and the intention behind agreements when there are competing claims.
It definitely makes you think. And maybe leaves a provocative thought for you, our listener. In today's world, where things move fast, deals can seem fluid. How do you make sure that the promises made to you are actually solid, legally binding? And what kind of checks, what due diligence would you do now to make sure you don't end up like Elise Weyman thinking you have a right to something, only to discover it was already promised away to someone else and you just stepped into a legal minefield?
Good question. Something definitely worth mulling over as you navigate your own agreements, whether they're for property or anything else.